Hello everyone, welcome to Court with Krissy. Today we have a plaintiff who has terminal cancer and his final wish is to just get divorced. Does he get his final wish? Watch and find out. I hope you like it. Court with Krissy is now in session.
Let's go on the record then and file 22-36303-DO. It's Babcock v. Babcock. We're here for two matters this morning. One is a pro-con and the other is a motion for entry of default judgment of divorce. Let me see. We do have Ms. Boyd is here on behalf of Mr. Babcock. Mr. Babcock is attending, as well as the defendant is present, and with her we have Ms. Bush from the Jail Diversion Program as a representative and support person. Ms. Boyd, in terms of the motion, I did have a chance to review it as well as the proposed default judgment of divorce, but any argument that you have, go right ahead.
Your Honor, I would just say this matter, as the court is well aware, has been pending for quite some time. A divorce without minor children. Obviously, we're well past the statutory, 60-day minimum for entry of a judgment. This continues to be an ongoing issue with the parties, just in as far as there's other court involvement, as you stated. Ms. Babcock is involved with some criminal matters, and my client also has a PPO against her. The reality is, after Mr. Elhart got out of this divorce matter in 2022, a stay was placed on the case, but since that stay has been lifted, there's been nothing done by the defendant. There's no witness and exhibit list filed. She failed to appear for the settlement conference. The reality is my client is extremely sick. He has cancer, and he has been waiting, trying to get this divorce done so that way he can properly prepare his affairs for when he passes. And he can't do that at this point in time, with this matter just continuing to drag on and on and on. And frankly, at this point, it feels as though this is a calculated move on the part of the defendant to ensure that she gets the marital estate when my client passes. And I know that is grim to talk about, but this matter really started because of threats the defendant was making towards my client, which is why there's a PPO and other involvement from the court as to criminal matters. So my client is just looking to get a judgment entered, allow him to be divorced and move on with his life. Ms. Babcock continues to be, at least from my understanding, continues to be arrested and released and bond and all of these other things. My client just needs to move on. He just needs to be done with her. She can go and do her thing. The parties haven't lived together or been together in over a year and a half. It needs to be finalized. And that's really all my client's looking for today.
Okay. Ms. Babcock, in terms of the motion for entry of a default judgment of divorce, do you have any comments you'd like to make, ma'am?
Your Honor, if I could just advocate a little bit for her.
Oh, sure. And Ms. Bush, I'm sorry, I assume that the camera isn't moving quite as quickly as the audio.
Sorry.
No, that's okay. It's not your fault. It's just the way the Zoom works. I just want to make sure that we're getting the correct person for speaking.
Yep.
Okay, go ahead.
So she has been in and out of the mental hospital on and off at least 4 times during this stuff. She's had stuff in district court. We just had court yesterday. We're going to get it wrapped up and finalized on the 29th in front of Judge Stepka. She hasn't been able to obtain legal representation because of the criminal matter, and she can't afford an attorney anywhere else. Her case manager and I at CMH have been trying. We've contacted at least 20 different attorneys, but until the issue is wrapped up in district court on the 29th of this month, the legal counsel aide won't be able to represent her.
Can you help me understand that last part? Why wouldn't somebody be able to represent her until the criminal case is concluded?
They said it would be a conflict of interest because she had a criminal case going with the defendant as well.
Okay. I guess I don't understand that component of it. I'm not saying that you weren't told that. I don't understand the logic or reasoning on their part, I guess. So, okay. Does Ms. Babcock have a specific request with all of that information, or is it simply just to inform my decision relative to the motion?
Just to inform your decision and hopefully push it back at least just until she can obtain the legal representation after the 29th. And I do have all the records stating that she was in and out of the psychiatric hospital. She's been complying with all her CMH stuff. I mean, every week she's got 3 or 4 appointments with us. She's doing what she has been for the district case on her part. The reason she missed the district case was because she was in the hospital for mental health. So, and that's why all the violations have been going on.
Okay. And where Ms. Bush, I don't know if you were there we had a show cause because Ms. Babcock failed to appear for something. And she did let me know that it was a similar situation. So I didn't take any further action.
I was in the waiting room, but they didn't let me in the court on time.
My apologies for that. We probably didn't know that that's what you were here for, because it wasn't a criminal case. This case is, quite frankly, always put the court in a tough position, and really the parties as well, given the extensive, I guess is the best word to use, background between the two of them, and the extensive mental health notations relative, especially to the defendant. And yet, as I called the case, it's hard to still believe that some of them start with a 2-2. And so the court does need to keep the case moving. The request has been filed for the plaintiffs, or on behalf of the plaintiff, for a motion for entry of default judgment of divorce. And based on the circumstances of the case thus far, and the legal ones, which is what the court has to use to analyze this motion, it's a perfectly appropriate request. And so what we're going to do procedurally, though, may be a little different. And so Ms. Boyd, what we'll do, the motion will be granted. I mean, legally speaking, the basis is there for that. The court can't ignore the legal basis regardless of the extent of everything else going on in the case. And so what we'll do is proceed with the pro-con. Mr. Babcock, what that means is I'm going to place you under oath in just a moment. And then Ms. Boyd is going to take some testimony from you to help me establish whether or not the statutory grounds for divorce have been met. Assuming that they have, normally what I would do, given that I've granted the motion for entry of a default judgment of divorce, and Ms. Boyd, that would need to be filed separately. I know you put it in as an attachment to the motion, which is perfectly appropriate for the court's review. We just can't pull it out to sign it. And so that'll need to be filed separately. What I will do, though, is hold off on signing it until after the 29th. If Ms. Babcock is able to obtain counsel and file a motion to have the default set aside, the court can review whether or not there is a legal basis for that. I'm not sure there will be, but I think fairness dictates that she have that opportunity. However, if that is not filed within 1 week of the 29th, the court will sign and execute the default judgment of divorce, because I have had a chance to review it and the terms of it are perfectly appropriate in the court's mind. So hopefully that timeline is clear for everybody. And so with that, Mr. Babcock, if you would please raise your right hand. Do you swear that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
I swear.
Okay, you can put your hand down, sir. If you could just start out by telling us your full name, please.
Nick James Babcock.
Thank you. Ms. Boyd, go right ahead.
Thank you, Your Honor. Nick, when you filed the complaint for divorce, had you been a resident of the state of Michigan for at least 60 days before the date of filing?
Yes.
Had you been a resident of Grand Traverse County for at least 10 days before the date of filing the complaint?
Yes.
Do you recall signing a complaint for divorce?
Yes, I do.
When you signed the complaint, were all the statements contained true?
Yes.
Are they still true today?
Yes, they are.
In the complaint, you stated that there had been a breakdown of the marriage relationship so that the objects of matrimony had been destroyed and there remained no reasonable likelihood the marriage could be preserved. Was that true when you signed the complaint?
Yes, that's correct.
Is that true today?
Yes.
Have you had a chance to review the property settlement provisions contained within the proposed default judgment of divorce?
Yes, I did.
Do you agree with those?
Yes, I do.
Do you agree that it is an equitable division of the assets and liabilities?
Yes, I do.
Are you requesting spousal support at this time?
No.
Do you understand that by not requesting spousal support now, you may not later return to the court and request spousal support?
Yes, I do.
To your knowledge, is the defendant currently pregnant?
No, she's not, to my knowledge.
To your knowledge, is the defendant requesting her surname be changed?
Not to my knowledge.
Thank you, Your Honor. That's all the questions I have for Mr. Babcock.
Okay. And Mr. Babcock, I think you were asked this question, but I was writing something down, so I apologize if I missed it. But prior to filing the complaint, were you a resident of the state of Michigan for at least 180 days and a resident of Grand Traverse County for at least 10?
Yes, Your Honor.
Okay. I was 90% sure Ms. Boyd asked that question, but I was writing something initially, so my apologies for that. Based on the testimony for the plaintiff, I will find that the statutory grounds for divorce have been met. And so we're going to proceed in the timeline or fashion that I indicated. The court did have a chance, as I noted, to review the proposed default judgment of divorce, the terms of which appear to be equitable and appropriate. And so, Ms. Boyd, if you could simply just refile that as a separate document so that it can be routed to me for signature. What I will do, as I indicated, the date that's been provided is that February 29th will be the conclusion of Ms. Babcock's criminal cases, at least in the district court. I don't have any cognizance of what those are, but what's been represented is that they will conclude that day. And so the court will wait 7 days after that date to sign the proposed judgment of divorce. That would give Ms. Babcock time again, if she is going to obtain legal representation. That should be a sufficient amount of time for that individual, whoever it is, to at least file a motion if they want to, seeking to set aside the default in this case, because that would also allow me to analyze whether or not a legal basis exists to do so. Okay. Ms. Boyd, any questions for you?
Should I just prepare an order and submit that under the 7-day rule along with filing separately the proposed judgment?
Yep, that would be perfectly appropriate.
Okay.
Okay. And Ms. Bush, on Ms. Babcock's behalf, any questions about the timeline?
Nope. Thank
Okay.
you, Your Honor.
Thank you all very much. I appreciate your appearance this morning.
Thank you.
Thank you.
Okay, let's go on the record then and file 22-360-303-DO. It's Babcock v. Babcock. We have Ms. Boyd here for the plaintiff, who is not present for reasons that we'll talk about, unfortunately, in just a moment. And then Ms. Babcock is here as well. Mrs. Babcock, can you hear me okay, ma'am?
Yes, I can, sir.
Okay. Ms. Boyd, let me start with you. We are here on Mrs. Babcock's motion and affidavit to set aside default. I have had a chance to review that document, but any argument that you want to make, go right ahead.
I don't know that at this point I can make any argument. My client passed away last week. So I believe at this point, without a party to continue forward in the divorce matter, I don't know that I'm able to make any argument.
Okay. Mrs. Babcock, do you have any argument you'd like to, do you want to take a minute, ma'am?
Sir, give me a minute, sir.
Okay. Why don't we go ahead and mute that real quick? We'll take a couple of minutes. And actually, I think what I'm going to do is I'll leave you all in the hearing room, but we had another case that was set for 8:30. So I'm going to bring them in. Both of you are free to remain in the courtroom, but Mr. Waldenmeyer, let's handle the Williams matter. Sorry to jump around on you, Cheryl, and then we'll come back to the Babcock case. Mr. Williams, can you see and hear me okay?
Yes.
Okay. And Ms. Neros, you can see and hear me okay?
Yes, I can.
Mrs. Williams, how about you, ma'am?
Yes.
Okay. Does your camera, is it functional or is it just audio for you?
Thanks, Dustin. We're all set.
Thank you.
Okay, let's go back on the record then in file 22-36303-DO. It's the Babcock matter. As was indicated by Ms. Boyd, unfortunately, the plaintiff in this case passed away. I think it was on the 12th, Ms. Boyd. And we're here for defendant's motion and affidavit to set aside the default judgment that was entered. And interestingly for the court, the default was entered prior to his death, and the proofs had already been taken relative to the divorce case, and so those were preserved. But I guess, Ms. Babcock, do you have any additional argument you'd like to make on your motion to set aside the